Marshall Batchelor versus Burl, Cain, Warden, 682 F3D 400. U.S. Court of Appeals, 5th Circuit, May 29th, 2012. In June 1998, Marshall committed a crime and was appointed an attorney, as he was too poor to afford one for himself. In 1999, he motioned for dismissal of his appointed counsel, as he wanted to represent himself in court. The court denied his request once in February 2000. Then Batchelor requested yet again for the dismissal of his appointed attorney so he could represent himself with his attorney on standby in case Batchelor needed any legal clarification. But his request was yet again denied by the trial court, and Batchelor was then convicted of armed robbery and sentenced to 60 years in prison. Batchelor then appealed to the higher court of his state, and it was found that the trial court violated Batchelor's Sixth Amendment right to represent himself in accordance with the ruling. At a trial of implement in the structure of the Sixth Amendment and applies to state court proceedings through the 14th Amendment, the court determined that this right was violated where weeks before a trial, he clearly declared to the judge that he wanted to represent himself and did not want counsel. And nonetheless, his request was denied by the trial court. Additionally, the court stated that a state may even over-object by the accused opponent a standby counsel to aid the accused if and when the accused requests help, and to be available to representation the accused in the event determination in the defendant's self-representation is necessary. Whether or not Batchelor abandoned his Feriata motion and thereby waived his right to represent himself is a question of fact. Our review of the court state record provides clear and convincing evidence that Batchelor's conduct was in no way inconsistent with his formal request to represent himself with the assistance of standby counsel. And instead of the state allowing him to represent himself, he was then sentenced to 60 years. And instead, the state contends that two events establish a reasonable basis upon which the state court could have found the Batchelor waived his right to represent himself after filing his October 1999 motion. First, Batchelor's statement to the trial court at the attempted arraignment that same day that he preferred not to enter a plea unless I have a presence of counsel, and second, the discussion of Batchelor's motion. The court violated his Sixth Amendment right to represent himself by denying a clear and unequivocal assertion of that right,